Friends, welcome to Lex Masters Law Academy. We are here after a long time. Let's start with the new topic, that is Indian Partnership Act. So let's begin. Firstly, we should understand what is partnership. Section 4 of the Partnership Act 1932 provides for the definition of partnership. Partnership is a relation. It is a relation of mutual trust, which mutual trust refers to honesty, integrity, and it is between persons. So the partnership cannot be between a single person. There need to be two or more persons. These persons can be a natural person or a legal person, like a company, corporation, limited liability partnership, certificate persons, oh, artificial persons, etc. Partnership firm is not a legal person. Therefore, a firm cannot enter into a partnership with other partnership firm. However, the partners themselves can enter into a partnership with other partners. Two joint Hindu undivided family can enter into a partnership, cannot enter into a partnership, but the Karta of the HUF can enter into do so. This is further supply. This is like you understand that firstly you should understand it is a relation between persons who have agreed to share profits, and the business is carried on by one or any of them by acting for all. Another important concept is, so you understand the relation that is of mutual trust, and which includes honesty and integrity. It is between persons. These are plural persons, two or more, which can be natural, legal, artificial. Then there must be an agreement. So partnership is not created by a status, but it is created by a contract which is expressed or implied uh, for example, in the cases of HUF, the identity is by status, not by a agreement. So the agreement is to share profits, and if the agreement is to share only the loss, then it cannot be considered as as a partnership firm. And partner does not get remuneration from taking part. He is not a salaried person, so he just get profits. And partners, all the partners are generally get equal share in their profits, in the profits of the business. Business includes trade, occupation, profession, which is carried by one or any of them acting for all. This is the concept of mutual agency, mutual, where everyone acts as an extended hand of other. And therefore there is the case of, if there are different rights, there is right of indemnity. If any partner does any act which is a fraud, then the firm needs to identify by the partner for his fraud, and partner is a agent of the firm, is provided in the section 18 for the business of the firm. And the partner needs to indemnify the firm, but the partner themselves, the firm will be themselves liable to the third person in any case or any wrongful act done by the partner. And individually, a person who have entered into this contract will be considered as partner, while collectively they will be called as the firm. The name of the business, the business, how the business will be carried out, by which name will be called as the firm name. The section 5 clearly states, which we have already dealt with, that the partnership is a creation of a contract which can be expressed or implied and not by the status, uh, which is the case of HUF. And the existence of partnership, whether there is a partnership or not, is decided but the facts and circumstances of the case itself. And the real test is the test that is the relation between the partners is to share profits and carry on the business. And the test is also of mutual agency. Explanation 1 attached to section 1, section 6 differentiates between co-ownership and partnership. Sometimes when two or more persons buys anything or purchases anything, they can become co-owner of that property. However, in that case, they will be co-owners, not partnership, because the intention is to own the property together rather than to share profits or carry on a business. So, a differentiation between co-ownership and partnership is that co-ownership is a result, not result of a contract. However, partnership is a result of a contract. There needs to be a contract. Co-owners can transfer their interest without the consent of the other co-owner. However, in cases of partner, it is not so. There is community of profits and losses in case of partnership. However, it is not so in cases of co-ownership. And in partnership, there is always mutual agency, which is not case of co-ownership. In law of agency and mutual agency, what is the difference? In law of agency, there is a principal, and thereafter there is an agent. However, in cases of mutual agency, there the partner is both the principal and the agent because they are the head and they are themselves the servant. Principal will be, if any act is committed by the agent, the principal will be liable. However, in cases of an act of the partner, the firm collectively will be liable, and the firm collectively is nothing but the partners themselves. And Section 6, Explanation 2 suggests that there can be share of profits, but there cannot be no partnership in certain cases. For example, if there is tender to money to any person engaged, for example, money lenders, remuneration paid to any servant, or a widow or child of a deceased partner is granted something, or in the cases of goodwill, sale of a goodwill or share thereof. So there will be share of profits but no partnership. This is so the real test is the essentials that you need to grab is that there are there's a relation which is of mutual trust, utmost relation of trust, honesty, and integrity between and relation between partners who have agreed that there should be an agreement between two or more persons who have agreed to share profits and carry on the business, acting by one or all. This is the cases of mutual agency. And Cox versus Hickman 1860 this says, in case that the facts are such that AB partners were there in iron business, Cox gives certain credits to the company, certain amount as credit to the company, and take over the company. Cox thereafter entered into a contract with Hickman to supply certain raw material, but he could not do so, and Hickman sued AB and all the creditors. It was held that Cox was only liable because the contract that was there was considered to be between Cox and AB rather than the entire firm. Because the thing was the Cox will take over the business of the firm, and after, as and when he will get the account settled, he will return back the partnership firm to AB only. That's the case between a partnership, and partnership can be a partnership at will, which is not a fixed duration. It is not for fixed duration, and that's the test to determine whether a partnership at will. Now it will be this, or there is no mode for determination of partnership. For example, in Moss versus Elphick, it was decided that the food business will dissolve by mutual consent. It is not considered as partnership partnership at will because there is a mode for putting an end to the partnership. And in cases of partnership at will, only notice in writing is sufficient to all the other partners to put an end to such to retire from such a partnership. However, for dissolution, notice in writing to all partners is essential, and as in when the date is mentioned in the notice, which will be considered as the date for dissolution of such partnership firm. If no date is mentioned when then the notice is so communicated will be considered as a date for dissolution of partnership at will. Then particular partnership is there. If a partnership is there for a particular purpose, it will be considered as a particular partnership. Thank you. That's all for today.